Back to our leading story this week now. State witness Slindelo Madlala's memory seeming to fail him as he testified at the Meyiwa Murder Trial, or as he continued to give testimony. Now, Madlala was in the house on the night the football star was killed during an alleged botched robbery. He's told the court that calling the police didn't cross his mind. Instead, he ran to the bedroom and hid his cell phone between the blankets. Now, Slindelo Masikane has been keeping a very close eye on proceedings. Now, Sli, when we last crossed to you, we're about to see the state re-examine Madlala, and that's where they left it, hoping to wrap up that testimony tomorrow. Can you bring us up to speed, please?
Certainly, so we've adjourned for the day. However, we do resume tomorrow with the re-examination of Slindelo Madlala by the state prosecutor. And of course, for much of the week, we have seen a grilling in terms of the defense poking holes in the testimony of Madlala, picking up inconsistencies between what he's saying in court and what he's said in several statements that he's made. But to just unpack some of the proceedings this morning, we're joined by legal expert Mr. Alton Hart from the UJ Law Clinic. Again, thank you so much for your time. Let's just start with what we are seeing this morning coming out of the cross-examination of Advocate Mshololo, who, like the defense for accused 124, has started introducing the version of docket 375. And she seems to want to put it to the court that Madlala may be testifying in a manner in which he is trying to protect himself, because there's a possibility he may actually be charged after the credibility findings of this particular trial. What do you make of some of the line of questioning that you heard this morning from Mshololo with regards to docket 375?
No, I think Advocate Mshololo she's right in the block. She is where she needs to be. There's no rules that prohibits her from using evidence from docket 375. As long as those statements were made, it was properly taken down and commissioned and everything, then it's good to go. The only thing is that she needs to lay a basis for the statements or the documents that she's introducing. So for me, it is actually a good tactic employed by Advocate Mshololo to come and say, now listen, yeah, there is this docket and you are a person of interest in that docket, and to try and now work with that, saying that you will now adapt your version in this court so that you are not implicating yourself and whoever that you are trying to protect. So for me, there is nothing wrong with it, and the state will object because that docket will become problematic, because there is information in there that has a total different spin as to what is currently before court. In that docket, there's information and damning information to the state's case that says that there was a fight between individuals, and now there was no intruders. The docket 375 actually says that there was no intruders, or it speaks to the narrative that there was no intruders. This was only a made-up story. And if that is put to it and the court finds that that is more reliable evidence than what's currently put before court, it means then the credibility of Slindelo Madlala is out of the window. And as Titi Tobani also, when Advocate Baloy raised the objection when Mshololo brought in 375, he rightly pointed out that these witnesses, they are in between a rock and a hard place, because if they don't testify and support the narrative in docket 363, then it means that they will be charged under docket 375. So to protect myself, I will testify in such a way that I make sure that these guys who is in the dock currently be found guilty, and then I can walk free. So what Advocate Mshololo did, the objection by the state, I don't think that was actually clever and wise, and it shouldn't have been done. And even his way of starting his re-examination, for me, I'm already saying I don't see that the prosecutor is acting in the interest of justice to make sure the real perpetrators is brought to book.
Now, a few times I heard the judge and the states going back and forth in terms of the objections by Advocate Baloyi with the line of questioning from Mshololo. At some point, Maumela saying, are we not discussing a docket that doesn't exist? Is this something that's, fair to say? Because just because there were no indictments served, I guess, on this docket, does it mean it doesn't exist? Does it mean that it cannot come up? Because, I mean, it is an exhibit in terms of this trial.
No, I think Judge Maumela is incorrect in his view, and I would state it uncategorically. Advocate Mshololo, her submissions made to court is correct, because this is an exhibit in court. It's before court. It's only, you can most probably go into the realm of saying, I'm going to treat this as hearsay evidence, and when the other person who made the statement come and testify, then I can now look at the weight that I will attach to a certain document or documents that was introduced under cross-examination.
Maybe then let's touch on what we can expect or what the state will try to achieve during re-examination. It seems we've lost our connection to Mr. Hart. I was really looking forward to hearing in terms of what we can expect in the line of questioning for the states. They are re-examining Tumelo Madlala. That is where we will pick up in terms of court proceedings tomorrow morning at 10 a.m. It's back to you in studio, Marcel.
Thank you so much. Slindelo Masikane bringing us the very latest there, where court is adjourned for the day as we bring you the live proceedings of the Meyiwa Murder Trial, and they will resume in the morning.